Welcome back, viewers, to the PI show. We've got that time of the show where it's the mailbag. Now, it's not Viv's mailbag anymore, Kathy. What's going on?
You've been on the mailbag.
Okay,
Tony.
it's a viewer's mailbag. You're very colourful tonight too.
I'm just trying to bring some colour into the law.
It's great.
You don't need sunglasses. Hey?
It's great. It looks good.
Well, good evening, and thank you for having me on again. Good evening, viewers. What an interesting show we had on before, though. Steph was great, talking to us about the
up-and-coming lawyer.
It's just
very topical.
Yeah, she's good.
We'll come back to it because there's a lot of issues that arise from that show.
And ongoing,
ongoing
news. It's ongoing news.
And once we know more about it, and the police investigation and the board's investigation, a lot's going to unfold.
Dare I say, legal proceedings commence.
That's exactly right. And Harry, by the way, we forgot to mention that there's a look-back program where people that have been treated at that clinic, the Health Commission have said that they should go and get tested at their normal GP's clinic.
Yeah.
Send it off, and they're going to be bulk billed, and people should get tested because.
Tony, the doctor may have an accident compensation claim for weekly payments and no fault benefits, Tony.
I don't know, Harry.
Well, how about we keep this for another show? So just keep watching, viewers. But let's go to our first question.
I don't particularly like him, Harry. I mean, just
he's probably got entitlements, Tony.
Well, our first question tonight, viewers, it's to the PI show. I am a truck driver and injured myself about 11 months ago. My main concern is, can work terminate my employment if it is proven that it was bad practices on the company's part as they did not meet with WorkSafe requirements, even if I haven't returned to work within the 52-week frame? And that's from Fritz in St Albans. Well, Harry, can you please answer that for Fritz?
Yeah, look, the law is a bit harsh because after 12 months they can terminate, so your employment rights are terminated if you're unfit to go back to your pre-injury work. So you need a clearance certificate from your doctor to say you're fit and can go back to your pre-injury work. Otherwise, work can terminate you. And then you've still got your rights under the Accident Compensation Act and common law. So weekly payments will continue, medical expenses will continue, you've got a right to sue at common law, and Fritz's claim, ultimately, if he succeeds at common law, will take care of the employment situation. That's my opinion.
Well, Harry, the philosophy of the Accident Compensation Act is to try and get people back to work. But I agree with you that unless Fritz gets back within the first 12 months to normal duties, or the company gives him alternative duties, then after 52 weeks he's got problems.
So do you believe that it extends to alternative or light duties as well? Or
within
would it
the 52 weeks.
To pre-injury?
No. I think if he's back on light duties, they have to give him light duties. If light duties are available, Tony.
Okay, yeah, I agree with you.
If light duties are available, he can continue in alternate duties for 2.5 years.
Well, Harry, without mentioning the names of these employers, I know for a fact that in some of the larger companies, if you don't get back to work within normal duties within 52 weeks, they terminate you.
They do. Some do, yeah.
So it's a live issue, and you've just got to get some advice, I guess.
Does that give rise to unfair dismissal then if it's within the 52-week time frame?
Not if you're on payments, because what's your loss? If you're receiving weekly payments, you don't have a loss.
That's right.
Yeah.
Okay, well, thank you for answering that. We'll move on to question number 2. Hi, in May 2010, my brother contracted Legionnaire's disease. He was under intensive care for 10 days and would have died if the staff at the hospital had not been so capable. He is still recovering and unable to work. He is self-employed. He has been advised he cannot make any claims as the source from where he caught the disease was never determined. My question is, who then is responsible? Is it worthwhile pursuing? If so, could you help him? Many thanks from Rita and Glen Iris. Tony, this is quite an interesting question. I mean, how do you actually determine who would be responsible in this instance, as it's very unclear?
You'd think that if he's caught it whilst he's in the hospital, on a balance of probabilities, that's where he got it. And
I think the question is that he went to hospital and his life was saved at hospital.
That's right. Yeah. That's my interpretation.
But didn't he contract the
No, not at hospital. No.
Okay.
No.
Oh, look, it's very difficult.
You can't. It's impossible. I mean, unless you can determine the source. So unless you can say, where he contracted, there's no wrongdoing.
As a rule, when there's a Legionnaire's there's a breakout, there's more than one person.
Yeah.
So
I agree.
And the health department generally pinpoint the source.
Yes.
So if we can pinpoint the source,
yes,
then usually what happens is you can take it to the next step and say they haven't properly maintained their air conditioning
It's
units.
an air conditioning issue, isn't it?
And then every occasion when it's happened, people have sued and received compensation. So I'd imagine
To our knowledge.
that Rita's brother is probably not the only one that's got the...
So I think it's a
disease
matter
from
of
that source.
just getting an investigator to investigate where
Where
he
he's
was,
been
where
and-
he's been,
Yeah.
and whether anyone else has contracted Legionnaire's disease.
And could you call the health department? Or
Oh, you'd have to.
Yeah,
You'd have
you
to.
would. You
And
should
then it could
notify the health
potentially-
department.
and then it could
They
potentially
might know,
even be a
they might have
class action.
information. They might have information that might assist.
Yeah.
So look, I understand it might unravel. That's how you
Yes.
would put it.
Okay,
Yeah.
so your first point of call probably the health department.
Claim was originally against, the first case in Melbourne I think was against the
The
aquarium,
It was against the aquarium.
and I think there were 10 defendants.
Wow.
10 defendants
And I
about
think
who was responsible for maintaining the air conditioning.
Maybe the old Australia Post building had a problem at one stage.
After that I think, yeah.
And
after
also
that.
other hospitals had a massive problem.
Yeah, the
And I don't want
hospitals.
to mention names in case they
No,
get
well,
their
it
back up.
was on the public record, Tony. But
But
I
don't
look,
want
I
to, I don't
think
want to mention the wrong name. So
Well-
I think there's been a number of cases in Victoria on Legionnaire's disease, which I agree with Tony.
I
They've
did
all been
one recently
successful
myself.
or
Yeah.
settled out of court. It's the owner of the building, the builder of the building, the air conditioning installer, the air conditioning maintenance person. There's a whole lot of people who might be liable. So again, once you find the source, then you've got to work out who is the real wrongdoer and sue them.
Kathy, time's moving. So
It is.
You
Well,
want to
let's-
remind people about sending further questions in and.
Absolutely, viewers.
Because I think we're going to run out of time for another.
That's
question.
right. We love receiving your emails and your questions, and I actually love sitting here questioning the boys so that they can answer them for you. So please write into www.pirshow.com and keep all your questions coming, as they make our job much more satisfying.
And Harry, this issue about the viruses, AIDS and hepatitis, it's a very topical subject. You know,
Yeah, well, it's ongoing
competing
and
interests of privacy and the public.
Yeah,
and, you know, it's
it's,
something that's going to have to be looked at because it's very, very contentious, isn't it?
yeah, it is. No,
And you
there's,
know, the public's health at large is pretty important. So I think I want to come back to this.
Tony, it's also the interaction of criminal activity or quasi-criminal activity versus civil remedies as well. So,
I mean, like, look, if you're
police often investigate, and I think the feedback of the Sydney case was a lot of people in Sydney didn't like the fact that there was litigation in court. They didn't like it.
Yeah.
So,
Well, it's, you know, the person's name comes out, but at the end of the day, bottom line, what's more important? You look after people? I think it's important that there's disclosure. You know, you meet someone, let them know that you're not well, that way you can take the necessary precautions. That's the way I see it.
Yep.
Anyway, look, it's been interesting to discuss this, Harry.
all right.
Kathy, thanks again.
Thanks
No
very
problem.
much.
Thank you again for
Thanks,
having
viewers.
me.
Thanks
Good
for
night.
watching, and see you next week.
Stay tuned.
Thanks.